You're sitting in the back of a police car. You haven't said a single word. And somehow, that might be the smartest thing you've ever done. Because in America, silence isn't just a right. It's a weapon. And most people never learn how to use it. Here's what nobody tells you. The moment a police officer starts asking you questions, you are already in danger. Not because you did anything wrong, but because the law is not designed to protect people who talk. It is designed to process them. Think about that for a second. You were taught to cooperate. You were taught that innocent people have nothing to hide. You were taught that staying silent makes you look guilty. Every single one of those lessons could put you in prison. This is the story of what actually happens when you stay silent, and why the law says you have every right to do exactly that. It starts with a case most people have heard of but few people actually understand. In 1966, the United States Supreme Court decided Miranda v. Arizona. Ernesto Miranda was a man accused of kidnapping and assault in Phoenix. He was brought in for questioning. He was never told he could stay silent. He was never told he had the right to a lawyer. And after 2 hours of interrogation, he confessed. That confession sent him to prison. The Supreme Court threw it out. Not because Miranda was innocent, but because the police had never told him he had a choice. That decision created what we now call Miranda rights, those words you've heard in every crime drama ever made. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Listen to that second sentence again. Anything you say can and will be used against you. Not might be. Will be. The law is telling you, directly and clearly, that your words are a liability. And yet, when a real officer sits across from a real person in a real interrogation room, that person almost always starts talking. Why? Because silence feels wrong. It feels suspicious. It feels like an admission of guilt. It isn't. In 2010, the Supreme Court revisited this territory in a case called Berghuis v. Thompkins. Vanchester Thompkins was a suspect in a murder case. He sat through nearly 3 hours of interrogation almost entirely in silence. Then, near the end, he answered a few questions. Those answers were used against him at trial. He was convicted. The court ruled that his silence, on its own, was not enough to invoke his Fifth Amendment right against self-incrimination. He needed to say, out loud, that he was invoking that right. That is one of the most important legal details most Americans never learn. Silence alone is not enough. You have to claim your right. Clearly. Directly. I am invoking my right to remain silent. I want a lawyer. Those 2 sentences. That is your shield. That is the legal line that, once crossed, forces the interrogation to stop. But here is where the story gets complicated. Let's say you are pulled over. A routine traffic stop. The officer leans into your window and says, "Do you know why I stopped you?" What do you say? Most people say something. They apologize. They explain. They guess. They say they weren't sure how fast they were going. They say they were in a hurry. They say something. And every single word of that something can be used to build a case against you. Here is what the law actually requires in that moment. You are required to provide your name, your driver's license, your registration, and your proof of insurance. In most states, that is the legal limit of what you must provide. Everything else is optional. You are not required to explain where you are going. You are not required to say where you came from. You are not required to say whether you have been drinking, whether there is anything in the car, or whether you knew you were speeding. You can say, politely and calmly, "I'm not going to answer questions without a lawyer present." And that is legal. Completely, constitutionally, undeniably legal. But then something happens that most people don't expect. The officer might get frustrated. The officer might say that your silence makes you look suspicious. The officer might tell you that things will go better for you if you just cooperate. That last one is the most dangerous sentence in any police encounter. Because here is what the research actually shows. Professor James J. Duane, a law professor at Regent University School of Law, spent years studying why innocent people confess to crimes they did not commit. His findings are staggering. Talking to police, even when you are completely innocent, increases your risk of prosecution. Not because the police are corrupt, but because the criminal justice system is built to find evidence. And the moment you start talking, you start providing it. Words can be misheard. Words can be misremembered. Words taken out of context can sound like admissions. Innocent explanations can contradict each other in ways that look like lies. The system is not built to find the truth. It is built to build a case. And you are the most dangerous witness against yourself. Now imagine a different scenario. You are not being pulled over for speeding. You are a suspect in a serious crime. You know you did not do it. And you think, you genuinely believe, that if you just explain yourself, the police will understand and let you go. This is the single most common thought that leads innocent people to prison. The Innocence Project, an organization that has used DNA evidence to exonerate hundreds of wrongfully convicted people, has found that in roughly 29% of those cases, the innocent person had made a false confession or given incriminating statements to police. 29%. Nearly 1 in 3 wrongfully convicted people helped put themselves in prison by talking. So what do you actually do if you are ever in that room? You are calm. You are polite. You do not argue. You do not demand. You say these words. I am invoking my right to remain silent. I would like a lawyer. And then you stop talking. The officer may continue asking questions. You do not answer. You repeat, if necessary, I am invoking my right to remain silent. I would like a lawyer. At that point, under the Sixth Amendment, the part of the Constitution that guarantees your right to legal counsel, the interrogation must stop. Any statement taken after you have clearly invoked that right is generally inadmissible in court. Generally. Because there are exceptions. There are always exceptions in law. Which is exactly why having a lawyer present is not just a right. It is a necessity. Now here is the counterintuitive part. The part that will feel wrong even after everything you have just heard. Invoking your rights does not make you look guilty to a jury. In fact, under Doyle v. Ohio, a 1976 Supreme Court ruling, prosecutors are generally not allowed to use your silence against you at trial if you invoke that right after being read your Miranda warnings. The jury cannot be told, he stayed silent, therefore he must be hiding something. The law knows that silence is not guilt, even if silence feels like guilt. Think about that the next time you are in a situation where someone in authority is asking you to explain yourself. The law built an entire protection around your right to say nothing. That protection exists because the founders of this country knew something important. A government powerful enough to ask questions is powerful enough to twist the answers. Your silence is not a wall you hide behind. It is the right they tried to make sure no one could ever take from you. You're sitting in the back of that police car again. You haven't said a single word. And now you know exactly why that might be the most legally intelligent decision of your life. So here is the question I want you to think about. If you were in that interrogation room, innocent, scared, certain you could explain everything, would you stay silent? Or would you start talking? And do you think the law makes it too easy, or too hard, for police to keep questioning someone who has asked for a lawyer?